Not a problem. Thank you. Um, I'll try and dive into it very quickly. I was going to say keep that mute button handy because you'll probably need it for me or the bell. I'm very happy to discuss Love and Toms and to present and to have been invited, and what I thought would be something quite
Sorry, Eddie, you seem to have muted yourself, I think. I hope it's you that's muted you and not us.
Sorry, how am I? There, good.
You might have to start all over again, but thanks. You're not the first to do that, though.
No. Basically, I'll just say, you know, what the year it has been in this case, and a task that I thought would be quite easy to discuss on this. Having gone back over the case and back over my notes and the various things that happened throughout the year, there's just so much to discuss with this, and that came up. So I've got my written remarks. I'll try and stick to them and go through. But I'd also like to acknowledge Aboriginal and Torres Strait Islander people across the country where we're all meeting today. And once again, it's important, and feel very privileged to be able to speak to you all today about this case, which is quite momentous in the history of Indigenous peoples and our relations in this country, but I guess more broadly, just from a jurisprudential point of view in the court, and the direction of all of that and where we've been heading, and this year, with the Black Lives Matter protests that we've seen world around the globe, and that they came here in Australia as well, and highlighted many of the long-standing issues in Australia with race relations and the place of Aboriginal and Torres Strait Islander people. And I think one of the main things as I get into this that really hit me again, I was reminded of the larger meaning of events or legal events like Love and Tom. So, for example, the 1967 referendum in Mabo, many people who teach in this area or deal with this would know that these events take on larger symbolic meaning than what they technically ever did as legal decisions or as institutions of our society. So a lot of Indigenous people are often fond of talking about getting the vote in '67 or not being counted as flora and fauna. And of course, these are all things that aren't correct. The vote having happened before that, and us never actually being counted as flora and fauna. But they speak to the larger issue or the bigger narrative of the issue that was present in Love and Toms, and this unresolved issue of the place of First Peoples, of Aboriginal and Torres Strait Islander people, in our political community. And I think I wanted to, recognise at the start as well that whilst we're dealing with these bigger issues, it's also important to note, that these cases, whilst momentous, deal with real people with, real issues, their real lives, and, have been detained or, have had freedoms removed from them that a lot of us would take for granted in our political community. And it's been a big year for those kind of issues and discussions to continue, and something that we're still striving forward to be able to achieve reform on always. I was also reminded, not only about the foundations of Australian state and how it's unresolved, and that's something that's not frozen in 1770, 1788 or 1901, as is often written about, but ultimately the limit of the courts and the legal system to be able to deal with these kind of questions and the need for greater political reform. So rather than address these issues meaningfully, I guess, at a larger political level throughout history, we've been left to navigate incomplete and imperfect compromises of the ongoing relationship between Indigenous and non-Indigenous peoples. And as part of this, and something that I think is key to the case and the narrative of Love and Toms, is that we too often fail to engage, or we lack the appropriate structural mechanisms to engage meaningfully with the reality of political legitimacy. So the greater question of the makeup of the Australian political community and where Aboriginal and Torres Strait Islander people fit into that today, and the implications of that for a modern settlement between Indigenous and non-Indigenous peoples. And I raise that issue because really what I'm talking about, the law is obsessed in some respects, and it often comes up with key dates such as 1788 or when letters patent for South Australia were issued and all that other kind of stuff. But the reality of political legitimacy is something much more complicated and messy that we face today, and being able to understand that and deal with that, but have the appropriate structural mechanisms to be able to deal with that as well, is something that is key to finding a meaningful modern settlement between Indigenous and non-Indigenous peoples. I wanted to step back a little bit and talk about belonging, which was such a key concept to the case as well, especially from an Aboriginal perspective, in the way I understand it and have kind of experienced this case and what it's meant this year. So belonging, at least from my perspective as an Aboriginal person, a public lawyer, and especially the attitude or popular feeling of disbelief at the idea that the question of whether an Indigenous person could be an alien was being asked at all, and why this is kind of important to understand in the response to the case, but also this larger unresolved issue between Indigenous and non-Indigenous peoples and the claims, you know, that we make on the Australian political community and the Australian state. And this was answered in my favourite of the 7 judgments. Let's not forget there were 7 individual judgments for this. For those of you wondering which one was my favourite as well, and Justice Edelman, who wrote that our connection and belonging is an underlying fundamental truth that cannot be altered or deemed not to exist. And, you know, despite this and despite that recognition, our belonging and what that belonging entails has been denied, and, you know, very much so continues to be denied by certain members or sections of our community today, even when we look at larger constitutional reform debates going on at the moment. And it's this experience of denial and the case that this case, and similar events must be considered within not merely as technical questions over the extent of Commonwealth legislative power. Further to this, also I think, which is important to note in this case, there is a truth in the common law itself, affirmed in this case, of Indigenous recognition of plural communities and peoples and protections against the application of unitary and absolute sovereign power to determine these matters. So this is, you know, something that has existed in the common law before the Australian state and its preceding colonies existed, and it's also something that's part of Indigenous legal traditions for thousands of generations that inform this kind of fundamental issue at the core of who we are as a political community in the Australian state. So from this, within this context, belonging as an Aboriginal person, I think is something that's not necessarily hard to explain, but hard to understand. And I think, you know, anyone familiar with native title case law since the early 90s, since the introduction of the Act, would be familiar with the direction and the development of, you know, connection to country and land and where that is at recently, which has been, you know, a welcome development to where we are getting to today. But understanding the importance of this, to who we are as Aboriginal people is key not only to the implications of the case, but to understanding and responding meaningfully to the claims made by Aboriginal and Torres Strait Islander people. And a short example I found recently when working with family of the meaning of this to us and to what happens into our understanding of belonging. So we found this newspaper article from the 1920s. 2 of my great-grandfathers and great-uncles were detailed in this newspaper article that was about a non-Indigenous man that had been charged for associating with Aborigines, which was an offence at the time under the Aborigines Protection Act. But there was one description of my family in this that kind of really stood out and hit at this idea of belonging. And that's the idea that my great-grandfathers, in description by police, were lost, and that they didn't know where they were, and they were lost and just kind of aimlessly traversing across the land. And so we don't know whether this was, you know, the excuse of our family at the time, as was often the case. And, you know, this is one of the jokes that's made quite often in Indigenous community about why you can't always trust anthropological reports or the kind of amateur reports of the time, because Indigenous people would often carry on and do those kinds of things over the time. But that there was this absurd idea that they could be lost. And so there's a lot in this, but I thought of this as the same feeling of disbelief when I read stories like that, or when non-Indigenous Australians have struggled to place me and my family as Aboriginal people in this land and political community. And so it's this tension and anxiety too in the greater Australian political community surrounding the application of authority over our people and the land that still informs fundamental issues about our legitimate claims and the failure to meaningfully respond to them. And so getting on to my final point that I want to draw out of the case as I was going through reflecting about political legitimacy and how we address these ongoing issues. And, you know, my argument being basically that I've written about previously too, that the court, you know, whilst has been beneficial to us in pursuing our claims because we've kind of been forced to have to go down that track, is ultimately limited as an institution, as a structural mechanism for us to be able to address these larger issues, and that political reform is required to be able to do that. And so I guess really, there isn't much in the case that I disagree with, aside from the points strongly that we're mainly in the minority about the implication that a further elucidation of the common law recognition of Aboriginal Australians equals a recognition of a dual or competing political sovereignty. But rather than kind of maintain these type of falsehoods, we require institutional reforms that can give effect to the fact that there are multiple and political and cultural entities in Australia. So it's very quickly finish this final point. It's cases such as these that are always imperfect and incomplete resolutions, even when otherwise desirable results are achieved. So, such as Mabo, we got the Native Title Act and the Common Law Native Title recognition out of that, but ultimately limited in being able to do so. And there's a couple more points there, but I'll just very quickly finish it by saying, the courts can and should only do so much here, and it's, for me, more than anything, Love and Thoms reminds me of the importance of not only political reform, but of developing a healthier and more flexible attitude to reform, especially of our constitution, the text itself, and the political and cultural traditions more broadly beyond that, based on what should be a social justice imperative at the core of who we are as a political community. Thank you, and my apologies for the time as well. Hopefully it's made sense over the parts that I've skipped.